But we've discussed this a lot, Jack and I have, and it basically comes down to we don't have some medical records for some of the places that the plaintiff treated. And we just didn't want to be surprised on the eve of trial if anything appeared at the last minute. We just wanted to have some guidance from the court that says, if you don't have it produced by this day, it just won't come in, or something along those lines. So, and Jack and I, we discussed it a lot. I believe him when he says he doesn't have certain records. I'm not questioning his credibility at all. It's just to establish just a deadline so that my clients can know how to proceed. Again, we mediate in about 9 days, so it might be a moot point in the first place. But
when is your trial?
And I believe Jack is
December
trial
6th.
setting. Let me find that, Judge.
Oh,
Yeah.
wow. It's December 6th. Okay.
I did check
think
that docket,
that's
Your Honor. I think there's 13, 14 cases that day, and we're about midway through the list. I don't know how
I will tell you, as a 2020 case, you have a decent shot of going.
Okay.
We're starting to try quite a few 2020 cases. It's earlier this year, it was all 2018 and 2019, but and I don't know, I haven't looked at your docket in particular, but I would not assume you're not going just because 2020s are starting to go. So but we'll see.
sure.
So Mr. Beasley, why haven't you, or have you produced all the medicals?
So thank you, Your Honor. We have produced a couple things. We've answered the discovery, as you've seen as attachments to both of our motions, or his motion and my response. The plaintiff has produced a MEDOF, a list of her treating providers. She's been deposed. Defendant is in possession of what she needs and what Mr. Spear needs, should they wish to obtain medical records on this case. Candidly, Ms. Burton treated at some places that are either not in existence anymore or didn't keep records, like a traditional chiropractor or physical therapist would in a car wreck setting. I've told Mr. Spear, and he is correct. This has been largely amicable between the two of us, and we have talked about this issue at length. He has everything I have. As I pointed out in my response, plaintiff can only produce what she has possession, custody, or control over. She's produced that. She's produced the MEDOF. I certainly understand defendant's position, and it's more appropriate for a trial argument. If evidence is introduced, an objection to the introduction of that, or perhaps a motion for a directed verdict on their behalf. Plaintiff's position is we produced everything. They've been in possession of everything that we have, including a MEDOF and the list of doctors this whole time. And so we'd ask that their motion to compel be denied.
So, Mr. Spear, it sounds like really what you just want is you don't want to get, broadsided at trial.
Right, essentially, right. And that's yeah.
So what I'm going to do is we'll do kind of a drop dead deadline of 2 weeks from today. Any medicals not produced by that time will not be admissible at trial. And it doesn't sound like this is kind of a belt and suspenders thing, but just to alleviate Mr. Spear's concern, I think that's perfectly fair. So Mr. Spear, go ahead and prepare an order for me. At the beginning of the order, it needs to say that this hearing was heard on November 7, 2022. Go ahead and e-file that and email it to Rhonda. Get that to me by tomorrow morning at 9 in the morning. So make sure you email Rhonda by tomorrow morning and share a copy of the order with Mr. Beasley. And it'd just be grant the motion to compel any medicals to be used at trial need to be produced.
Yes, sir.
We lost Mr. Beasley, I think.
Oh
well. Maybe he was upset by the ruling. I hope that's not it. So, but you guys have a great rest of your day, and just get me the order as soon as you can. Okay.
Yes, sir. We'll do. Thank you so much.
See you,
Have a good day,
Mr.
Judge.